did want to let the court know I've identified a possible CARES Act issue with this case, but we'll still work to see if we can resolve it with plaintiff.
You better resolve it.
Pardon?
I mean, I said what I said. You better resolve it. Avalon Housing versus Vicki Bennett.
Shelia here for plaintiff.
Dave Morris for Vicki Bennett. She is appearing by Zoom this afternoon, Your Honor.
Oh, there she is. All right, ma'am, can you state your name?
Vicki Bennett?
All right, thank you. All right, where are we on this case?
Your Honor, Mr. Morris and I have spoken. We're hoping to resolve the issues in this case. I think Ms. Bennett has raised some repairs issues. We need to schedule a meeting, and I think I just haven't been able to get a good time with our schedule's been a little bit busy this past couple of weeks, and my client's schedule's been a little bit busy this couple.
All right, so if I turn this out a couple of weeks, you get.
Yes, Your Honor, but I would like to make a record.
Oh, go ahead.
Okay. Well, Your Honor, I think that this case should be dismissed, and we can work things outside of this litigation. The plaintiffs have failed to state a claim. They did not attach a copy of the lease agreement as required. Your Honor asked me 2 weeks
They
ago.
can correct it. You want a copy of the lease agreement? Have them send it.
Your Honor, the facts are, Your Honor, that 2 weeks ago, you asked for me to provide case law on that being mandatory. I provided that in my answer to the complaint as an affirmative defense. But moreover, Your Honor, you instructed plaintiff's counsel to provide a copy of the lease 2 weeks ago. I reminded them by phone later that day. It is 2 weeks later. I was forced to answer without a copy of the lease. This is not the way that landlord-tenant matters should be conducted.
Oh, it's always worked that way, one way or another.
Well,
The last 40 years I've been doing it.
Respectfully, Your Honor, the Michigan Supreme Court believes otherwise by the rules. And I would just state that the plaintiff does not get to determine what is relevant to a landlord-tenant matter. We believe that there are repairs, reasonable accommodations that weren't made, and those are violations of the lease. They believe that
One trial.
No, Your Honor, I want to work this out, but I would like for sanctions against.
I'm not sanctioning.
Your Honor, this was signed in violation of 1.109E.
I am not sanctioning. Go ahead, you make your record. I'm not sanctioned.
Thank you, Your Honor. Alternatively, we would like for costs for a dismissal, if Your Honor would be inclined to dismiss this case.
Motion for dismissal denied.
Thank you. Thank you, Your Honor.
Case is adjourned. You walk away from the podium while I'm talking. You want sanctions, I'll give them to you. August 29th, 2025. What time? 3 p.m. Thank you. Now you're excused.